Dennis Moonsammy, Dennis Moonsammy.
May I proceed?
You may proceed.
Good afternoon, Sergeant Moonsammy.
Good afternoon, sir.
Can you tell the ladies and gentlemen where you're employed?
I'm employed at Orange County Corrections.
Okay. Are you currently the supervisor of the women's detention center of a certain shift?
Yes, sir.
Okay. And would that detention center include the location where Caylee Anthony has been since October 14, 2008?
Yes, sir.
And is Caylee Anthony currently under some type of special status there?
Objection, relevance.
If I can have a little leeway, I can tie it in, Your Honor.
Objection, relevance.
Sustained, it's relevant, and you can approach.
Yes, sir.
Ladies and gentlemen of the jury, there is going to be a not too brief legal matter we need to take up outside of your presence. I understand you have a 7 o'clock engagement tonight. So what we're going to do is let you get back so you can get comfortable change and be at your engagement tonight. Please remember all of my previous admonitions, not to discuss this case among yourselves along with the other things that I've told you about in the past. Any additional instructions on behalf of the state or the defense? See you in the morning, ladies and gentlemen of the jury. Okay, Mr. Baez, you may proceed with your proffer. I'm sustaining the state's objection on matter of relevancy, but for the purpose of the record, I will permit you to proffer the testimony.
Sergeant Moonsammy, can you please describe Miss Anthony's status at the jail? Custody status.
She's a protective custody, otherwise known as PC.
And what are the requirements of a PC inmate?
Well, one of the main requirements are that in Mrs. Anthony's case, because it's a high-profile inmate, we don't put them in a general population. Or if an inmate comes in and requests it, they will go to the inmate affairs, and they will determine after investigating it whatever this inmate actually deserves protective custody.
Okay. And does that require her to be in her cell for extended periods of time?
Yes, sir.
How long does she have to be in her cell?
23 hours a day.
Okay. And that 1 hour a day, what does she get to do during that 1 hour?
She's allowed to take a shower, go to the rec yard, go to the TV room, or get a book from the portable library that's in that particular unit.
And has she been in protective custody for the last 2.5 years?
I'm sorry, sir, I didn't get the question.
Has she been in protective custody for the last 2.5 years?
Yes, sir.
Okay. And how would you describe Miss Anthony's demeanor?
Miss Anthony is a model inmate.
What is she like when you see her and engage her?
It's part of my responsibility to go to that unit every day and do a supervisor tour, and also ensure that I speak to every inmate in that particular area. I have to engage them. I have to have a response from them, which I record on something we call an OP8. And every time I have spoken to Miss Anthony as part of my responsibility and duty, she's been very pleasant, always smiling without hesitation, never give us any problem. Doesn't matter if I come early and I have to knock on her cell door to wake her up. She always responds very pleasantly.
Does her behavior, being locked up under those conditions, is it different than other inmates?
I'm sorry, sir. Different in what way?
Does her behavior seem unusual to you?
My job is care, custody, and control, and that's what I do. And I pay little or no attention to the inmate's behavior, except if it's, if it's break real bad or they become, uncontrollable in the discipline or a behavioral mode. So I suppose to correctly answer your question, her behavior to me is the same as almost all the inmate in that area.
Let me ask you this: have you engaged Miss Anthony outside of that small time that you're supposed to acknowledge them? Have you spoken to her outside of that area?
I have spoken to her, and she have engaged me when I walk around to do my tours. She have engaged me in conversation, yes.
And is she always pleasant and happy?
Yes, sir. She's always pleasant and she's always happy.
Okay. And that is despite her current situation?
Yes, sir.
And is it fair to say this behavior has been constant from October 2008 till today?
From the day Miss Anthony was incarcerated until the last day of work, which was Sunday, her behavior has never changed. She has been the same person. She is constant as it be. Nothing, she's never up or down. She always smiles and she's always pleasant.
Okay. No further questions, Judge.
Cross-examination by the state.
No questions.
Okay.
We would now call Marlene Baker.
Okay.
Yes,
The
you may.
court will maintain its previous ruling that is not relevant or material. Thank you, Sergeant.
Marlene Baker, Marlene Baker.
Good afternoon, ma'am.
How you doing?
Good. How are you employed and where?
I'm employed with Orange County Corrections, presently working in classification.
Prior to working there, did you work in the Lima dorm in the Women's Detention Center where Caylee Anthony is housed?
Yes, I did.
And how often or how long did you work there?
In that area,
Yes.
at least 7 years.
Okay. And how long did you have an opportunity to observe Miss Anthony?
From the time she was first brought in until the time I left, which was 2010, I'm sorry.
So you had an opportunity to view her on a daily basis for a year and a half?
Yes, sir.
And how would you describe Miss Anthony's demeanor?
Pleasant.
And when you say pleasant, can you give us some examples?
When we'd come in the mornings to do our visual inspection, she always had a pleasant attitude, even waking her up out of her sleeper.
And is Miss Anthony under current protective status, PC status?
When I was working there, yes, she was. I'm not in that area anymore, so I'm
Okay.
pretty sure she is. So
Okay. And being under those conditions, does that often cause inmates a lot of stress? Being locked in how large is the cell?
6 by 8.
Okay. And she would have to be in that 6x8 cell for 23 hours a day?
Yes.
And does that often cause inmates quite a bit of stress,
Yes.
especially those facing the death penalty?
All of them. It is being an inmate in a small area where you're confined, and it would cause any inmate, for the most part, some type of problems as far as being in that cell and confined for 23 hours a day, or some even almost 24. So, yes.
And did Caylee Anthony's behavior ever change as far as her behavior, her pleasant demeanor?
Only when maybe she was upset about something, she would cry. But as far as, what do you mean?
Her general demeanor, did she ever allow her condition, did the conditions ever affect or change her pleasantness and happiness?
Maybe only when she was upset or crying about something. That's the only time.
Would that be often?
To my recollection, no.
Okay. Is it fair to say that she was always happy and pleasant?
She was always pleasant, yes.
Okay. Did she always smile around you? Was her demeanor, can you describe it a little more? Give us a little more detail.
She smiled quite often, yes. Yes, I would say yes.
And this is despite the conditions that she was under?
Yes.
And was her behavior consistent from the day she got there to the day you left?
Yes.
I have no further questions.
State, any questions?
No, Your Honor.
Okay, court will stand by the previous ruling. It is not relevant or material to the material issues in this particular case. So if the state objects to that on relevancy, I would sustain the objection.
I would also include, Your Honor, under our response that the before testified testimony also goes to the theory of defense.
Again, the theory of defense must be relevant and material. And
Very well, Judge. Based on the prior state's motion in limine, we'd like to proffer the next witness's testimony and then get a ruling on that.
which witness is that?
Jesse Grund.
Okay.
Okay. He was released. We could take it from there.
If you want to, or you can proffer his testimony. I have no idea what he would testify to.
Your Honor.
May I make a suggestion? Perhaps just the portion of his deposition that reveals it, the court can review it.
We could do that.
I mean,
We could do that. Let me
Is
see.
his deposition on file?
Or we could take the sidebar and address it in 5 minutes. I think we can address it sidebar in a matter of minutes.
Okay. Madam Court Reporter? You may proceed.
Thank you. Good afternoon, Mr. Grund.
Good afternoon.
Mr. Grund, was there a time when you were in...
State his full name for the record, please.
Yes. Could you please state your name for the record?
Jesse Grund, Grund.
Mr. Grund, was there a time where you were engaged to Caylee Anthony?
There was.
And do you recall a conversation that you had with Caylee Anthony shortly after Caylee was born in reference to her brother Lee?
Yes, I do.
Okay. Can you tell the court what prompted that conversation?
I felt uncomfortable with Lee Upon first meeting him, he was very standoffish, very strange, very quiet, very sullen around me and around Casey and Caylee. And I wanted to know why.
And did Casey express an opinion or a desire not to have Caylee around Lee?
Yes.
And did you ask her why?
Yes, I did.
And what did she say?
She told me at one point in recent years that she woke up one night with Lee standing over her in bed, staring at her sleep. And in another instance, was groping her in the middle of the night.
And when she told you this information, did you want to continue the conversation?
No, I had absolutely no interest in continuing that conversation.
And why?
That was all I needed to know at that point. Anything that Casey said, I took as truth and fact. So she told me that that was why she felt uncomfortable around Lee. I didn't want to have anything to do with him.
And did you kind of cut the conversation off short?
I would say that I basically told her, if I remember the conversation correctly, that was all I really needed to hear.
Okay. I have no further questions, Judge.
State. Okay, sir, you may stand down.
Sir?
You want to give him some instructions?
Yes, sir.
Okay. So the court will have the defense's theory correct as I consider this matter. The state is objected on the basis of hearsay.
Your Honor, if I might specifically cite the court to 90.803 3B1.
803.
803 3B1, which specifically states, and this is the subsection on then existing mental, emotional, or physical condition. It specifically excludes an after-the-fact statement of memory or belief to prove the fact remembered or believed, unless it relates to execution of a will. I believe that A indicates that then existing state of mind may be proven by such statements. And as we discussed at the bench, there's an issue as to whether her state of mind I'm not sure that that proffer actually said when this statement was, but obviously I think counsel said it was 2006. 2005 is not relevant, but even if the statement, I don't want Caylee to be around Lee, were admissible, certainly the after the fact statement about what happened and why would not be. It's specifically excluded under the statute I just mentioned. But our position would be that the entire matter is hearsay because it doesn't go to a state of mind at a relevant point in time to this case. Right. Yeah.
Anything else from the defense?
Judge, we may have further argument in the morning. We'd like to have the evening to review it and see if there's any additional support that we can give the court other than the one that we gave at sidebar.
Okay. As I indicated to you before, the research I had previously done indicates that it is not admissible under the state of mind exception to the hearsay rule. But I will look again tonight to see and see if I can find some cases. I invite both sides to submit whatever cases they would have. Now, I think someone indicated that Ms. Fennell wanted to take up the issue of the death penalty motion in the morning at 8:30, and she wanted to do it via telephone.
That was my understanding from Ms. Sims, who isn't here at the moment, but And I had suggested that we do it by phone so she didn't have to come down just for this. And I'll be prepared to respond to the extent that I need to. We also discussed briefly about the proffer on the witness Cariuth, and when that should be done. So we will need to discuss that as well.
Do you have her deposition?
We didn't take her deposition because I was informed by counsel that she had been given no information about the case and knew nothing about the case. And without knowing what hypotheticals might be offered, there was no point in my deposing her because I don't know what to ask her about. Counsel agreed in lieu of that to simply proffer her testimony so that we can know what she's going to be asked about. Obviously, there's no report from her about this case. So that's what we had agreed to do, is to have a proffer of her testimony. Obviously, without knowing what she's going to be asked, I can't even really make an intelligent argument about the admissibility of it other than some general case law that the court's provided and that I've read. So that's what we had agreed to do, is to proffer it.
That statement's a bit incomplete.
Okay.
We had Dr. Cariuth available. In fact, she came in on Saturday. She had a tech support person ready to take her deposition via Skype. Mr. Ashton asked us if she had any facts, specific facts about this case. We told him no, that she was going to speak generally, as is in her report, which she submitted immediately. And Mr. Ashton chose not to depose her. Now, I have long been objecting to all of these proffers of here's an advanced preview, go get ready. And I'm going to object again. I think this is, it's absurd to try a case this way. And I realize there are certain situations like the motion in limine that's been made and like the ones that the court has recognized, but it's got to come with stop. These have to come to an end, and they've got to be ready to try the case and not expect an advanced preview. If Mr. Ashton really wanted to find out more information, he could have taken her deposition and then asked her questions about her report, asked her questions about grief, asked her what she expected to testify to, but he did none of those things. Now I have to ask her to come down from Tallahassee, and then with the hopes that she may or may not testify. And that's the issue that I have here. If she comes down, I'd like her to testify, Judge. If not, we can put witnesses through these things.
With the proffer being by telephone,
Why didn't you take her deposition?
Because the precise conversation was this. We had scheduled her deposition at 2:00 on Saturday afternoon. This was the Saturday when Mr. Rodriguez, the Rodriguez issue began. We had to start Mr. Rodriguez's deposition at 1:30. We didn't finish his deposition until 3:30. Ms. Cariuth had been sitting at a neighbor's house for an hour and a half waiting for us to get to her. I asked counsel, I said, does she know anything about this case? He said no. I then said, well, do you have a problem with just proffering her testimony before the court? And counsel said, no problem. And Mr. Mason was there, as I recall. And now apparently, I don't know if counsel is now going to say that, I'm sorry, Judge, I just find myself in this position again. But that's why. There is nothing I can ask this witness who knows nothing about the case that will help me prepare. It's impossible for me to guess at what hypotheticals counsel might ask this witness. And counsel, in my presence, and I wish I'd got it on the record, my mistake for not, said no problem with the proffer.
I think it's pretty clear here. It was a late Saturday afternoon. We were all tired, including Mr. Ashton, and I understand him not wanting to take her deposition. The fact is, he didn't take her deposition, okay? And he had a report of what she was going to say. I am willing to give, as in her report, a general proffer of the topics of which she will testify to. Am I willing to agree to have her come up here, testify, and then do it, give him an advance preview, and then do it again? The fact of the matter is, he had the opportunity. She did wait around for an hour and a half. She inconvenienced another individual to do that to accommodate Mr. Ashton, and he didn't take advantage of it. Now he wants to come in and it's one of those situations where you give an inch, they take a yard. And it's just never ending. And rather than, throw around the accusations, this has been going on for 3 years. I get it. There's issues on both sides, but that doesn't give you the right to neglect your responsibilities. If you want to come back and say, this is what I want, you should do what you were expected to do, which was take the deposition. She took the time out on a Saturday afternoon after just arriving from Europe to accommodate Mr. Ashton. He was tired, as was I, and didn't do it.
Is the witness being called to testify as to the issue of general grief? Is the witness going to be asked hypothetical questions based upon the evidence that has thus far been presented? Yes. Has the witness interviewed Ms. Anthony? When had you planned on calling the doctor as a witness?
She's scheduled to be here tomorrow morning.
Well, I don't have a crystal ball. I have no earthly idea what this witness is going to be asked or what she is going to say in response to the questions. I have tried to be upfront with everyone. I have given you every case that I know of that deals with the subject of grief. I even told you of another case that I found, which is found at 12 Southern Edition 3rd, 255. They're depending on what she is going to say. Some of it may be admissible. Some of it may not be admissible. If there's a hypothetical similar to the case out of the first DCA based upon record evidence, then she can explain as a result of that hypothetical whoever grief would have it. The other cases that I've cited to you where they excluded it, it was quite evident during jury selection that the members of the jury, through the questioning of the attorneys, had been questioned about their experience with death and grieving. The court concluded that because the jurors knew about death and grieving, there was no need for expert testimony on the issue of grief. If memory serves me correctly, there were no questions asked of any members of this jury whether or not they've had any experience with death or grieving. Thus, there is a possibility that the evidence may be admissible depending on what is asked, what hypothetical is asked based upon the testimony that has been thus brought forth during this trial. So the best thing I can do is listen to the testimony. And I guess we'll go in and out like Pop-Tarts tomorrow dealing with this. Hopefully there will be a well-constructed hypothetical consisting of record testimony. The testimony should not be any mystery since all of you have been capturing, put it this way, you've had the ability to capture the testimony since you both have monitors at your table. And all you have to do is save it on a jump drive at the conclusion of each day. So there shouldn't be any mystery as to what the testimony is. And if there was some mystery and there was some discrepancy, you could have made request of the court reporting services to get certain testimony if you were unclear on how to retrieve it. I think I even gave the defense my cheat sheet for how to save the testimony, and I think I offered that same cheat sheet to the state of Florida. So we will see tomorrow what the testimony will be. Let me ask you this, how many more witnesses after the grief counselor we have?
I think about
Half dozen? Okay. At the conclusion, before the defense rests, you know I will be making the necessary inquiry concerning whether or not, if the defendant chooses not to testify, I will have to inquire to make sure it's her decision and her decision alone. If you should happen to find any cases tonight, since I do like to read them, email them to me so I can either read them, at least I can read them first thing in the morning. I think both sides have access to my email. Make sure you copy the other side. Anything else for the good of the order? Yes? Yes, sir.
this phone call tomorrow. Is this for the record and it is going to go to the media?
The phone call, which phone call? Ms. Fennell, yes, it's for the record. She's going to be arguing a motion.
So this is going to go to the media as well?
It's going to go to anybody that has a pair of ears. Madam Court Reporter, before you leave, email me the copy of Mr. Grund's short testimony to proffer so I can peruse it. Anything else for the good of the order? We'll be in recess at 8:30 tomorrow morning.